Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I'm going to cover a case that a lot of you have asked me to explain, but it's a very sensitive topic. It's a case of a woman who's seeking medical assistance in dying, so she wants a doctor to kill her. And her father is trying to prevent this, and there's a court battle ongoing. So I'm going to try to explain the legal issues and the court case thus far, but I'm not going to try to tell you what to think about this one. This is a very controversial topic, and you guys can make up your own minds. This is also subject to a publication ban, so we've just got initials. If you know their real names, don't post it in the comments. I don't ban people for much, but I'll ban you for that. All right, let's dive in. So this is the case of WV and MV. Now, WV is the father and MV is the daughter. And this is an adult daughter, so she's an adult. All right, let's have a look. So, introduction. MV is a young woman who's been approved by 2 doctors to receive medical assistance in dying. MV's father, WV, believes that she is vulnerable and is not competent to make the decision to take her own life. He says that she is generally healthy and believes that her physical symptoms, to the extent that she has any, result from undiagnosed psychological conditions. And this is important because of the legal test. We'll get to that. He submits that she does not meet the criteria to be eligible for MAID, that's the medical assistance in dying. At WV's request, that's the father again, Justice Belzil issued an ex parte interim injunction on January 31st, 2024, preventing the daughter and Alberta Health Services from going ahead with her scheduled appointment to receive MAID. So he went into court and, without her present, asked the court to block her death. And the court granted that, and now she is in court saying, end that injunction. So that's what's at stake here, is that if this injunction ends, she will be free to end her life. So the daughter brought the present application to set aside the interim injunction. The daughter has not provided any evidence to contest the facts asserted by her father, nor has she identified her medical condition or provided information concerning her symptoms and how they cause her to suffer, apart from evidence that she's been approved by 2 doctors to receive MAID. And we'll get into this because there's some funny stuff about the 2 doctors. So the daughter's position is that her father has no standing to contest her private medical decisions or the clinical judgment of her doctors. The daughter maintains that her decision to seek medical assistance in dying is personal and private and not reviewable by the court. She asked the court to respect her autonomy and her right to die with dignity. Now, standing is a complicated issue, and that is basically you can't interfere with using the courts in other people's business unless it's somehow connected to you. So, for example, let's say a store is being sold to another person, and I think there's a problem with the contract, but I'm not one of the people involved in this deal. I can't sue to block this based on I think there's a problem with the contract because it doesn't concern me. It's not my business. So, the issue here is that the daughter is an adult. And as an adult, she can make her own medical decisions. You know, if a while back, I had my appendix out and I had the option of surgery and to have it removed or antibiotics to try to stop the appendicitis. And I chose the surgery. My parents would not be able to interfere with that decision. That's my decision. Now it gets a little more complicated and a little more difficult when you start talking about this kind of decision because it really sort of affects us in a different way. I don't think my parents really have much thought about my choice about how to deal with my appendicitis, but they might have a very different set of opinions and different set of feelings if that was a medical assistance in dying. So that's really what's at stake here. And the court is going to have to navigate this. And it's a very difficult question. I'm not going to, say that it isn't. It's a legally difficult question because of the context. Okay. So let's sort of have a look further. The court says, I explain in these reasons that the father, has raised justiciable, which means basically issues that the court can decide. The court can't decide everything, right? If I go to the court and I say, hey, should I have cereal or toast for breakfast? The court's going to say, that's not an issue for the court. Go away. But this is a little bit more serious than that, right? It's a complicated question, but can the court deal with this? Is this something that the court can interfere in? And serious issues to be tried, including whether Alberta Health Services follows its own MAID policy. Given the importance of resolving these issues for MAID practitioners and people interested in applying for MAID, I conclude that the father should be granted public interest standing. So that is that he is standing, but not as like a private actor, but instead this is something that's normally given to like charities or aid groups or representative groups in various fashions. So this is an interesting sort of workaround that the court has reached. Despite my findings on these issues, I am persuaded that in the final balance, the daughter's dignity and right to self-determination outweighs the important matters raised by the father and the harm that he will suffer in losing the daughter. The interim injunction is set aside. So we'll talk about that and what it means and what the next steps are here, because this is going to be a big case. There's probably going to be a lot of coverage over it. It's a heavy issue. All right, so I'm going to skip over a lot of the discussion of the history, but I will link this case in the description below so that you can check it out if you want to read the full thing. But we're jumping over to the Criminal Code MAID framework. And why, you might be saying, why is this in the Criminal Code? Well, normally, as a starting point, it's illegal to intentionally kill a human being. Now, there's defenses to that, like self-defense, and some other sort of circumstances. But as a basic rule, you can't kill people. And so MAID is a bit of an exception to that in Canada, but there's limits on it, and we'll talk about the limits on it and the significance of that. So in order to be eligible to fall under this exception, there are 5 criteria that must be met before a person may be eligible. These criteria are, first, they're eligible or but for any applicable minimum period of residence or waiting period would be eligible for health services funded by a government in Canada. What's this provision for? It's to prevent people who are foreigners from coming to Canada for MAID. That's really what that's about. They are at least 18 years of age and capable of making decisions with respect to their health. So that capable of making decisions means that, you haven't reached incapacity for some reason of serious mental health or the like. They have a grievous and irremediable, lots of tough words in this one, medical condition. They have made a voluntary request for medical assistance in dying that in particular was not made as a result of external pressure. So if you can show that somebody was pressured into it, this doesn't apply. And they give informed consent to receive medical assistance in dying after they've been informed of all of the means that are available to relieve their suffering, including palliative care. Now, palliative care means sort of measures to make the dying process less painful. So, all right. Criminal Code section 241.2 sub 2 explains what the term grievous and irremediable medical condition means. A person has a grievous and irremediable, I think I did better that time, medical condition if they meet all of the following criteria. First, that they have a serious and incurable illness, disease, or disability. Second, that they are in an advanced state of irreversible decline in capability. So there can't be any sort of prospect of them getting better. And that illness, disease, or disability, or that state of decline causes them enduring physical or psychological suffering that is intolerable to them and that cannot be relieved under conditions that they consider acceptable. Now, MAID is controversial in Canada and controversial generally. And part of the controversy is the concern that it might be overused. And this case is really going to put that at the forefront. So there's two sort of tracks. And track one is where natural death is reasonably foreseeable, i.e. you're about to die. It's going to happen soon, and this is just speeding things along. But track two is what we're dealing with in this case, where natural death is not reasonably foreseeable, i.e. you're not dying, but you might be suffering in some way and want to end your life. So this is substantially more controversial and more difficult to navigate. So the criminal code sets out safeguards for track 2 MAID. Those safeguards include that the medical practitioner or nurse practitioner must be of the opinion that the person seeking MAID meets all of the criteria in subsection 1, ensure that the person is informed that they may withdraw their request at any time. You can change your mind right up until it happens. After that, mind changing isn't really a thing, but ensure that another medical practitioner has provided a written opinion confirming that all the criteria set out in subsection 1 have been met. Be satisfied that they and the other medical practitioner are independent, and ensure that the person has been informed of the means available to relieve their suffering. So there's got to be two people who both sign off on it. And here's where some of the problem is going to be. So subsection 6C explains that a medical practitioner or nurse practitioner is independent if they, A, are not a mentor to the other practitioner or responsible for supervising their work, so they can't be, in that kind of relationship. B, do not know or believe that they are a beneficiary under the will of the person making the request or a recipient in any other way of a financial or other material benefit resulting from that person's death, other than standard compensation for their services relating to the request. So they're allowed to be paid for, like, I'm a doctor who who's worked at this for an hour or whatever. What they're not allowed to do, they're not allowed to be like in the will. So it's not like, hey, if you approve this, I will leave everything to you. And then that would get a little sketchy, right? C, do not know or believe that they are connected to the other practitioner or to the person making the request in any other way that would affect their objectivity. So, though both the Criminal Code and the Alberta Health Services MAID policy contemplate that doctors and nurse practitioners are to determine for themselves whether they are independent, the question of independence does not involve medical expertise. Further, the evidence of Dr. S.G., reviewed later in these reasons, shows that Alberta Health Services plays a significant role in recommending and selecting MAID assessors for patients, and the Alberta Health Services MAID policy statement of applicability explicitly extends to all Alberta Health Services employees. This is going to be a significant element, how these doctors were chosen. So, there is an exclusion for people whose sole condition is a mental illness or disability. And so the father argues that the daughter's condition, to the extent that she has a condition, is mental, not physical in nature. He contends that the daughter should not be eligible for MAID because it is not available at this time to individuals whose sole condition is mental illness or disability. The doctors who approved the daughter for MAID were required to apply the criteria in the Criminal Code, follow the Alberta Health Services MAID policy, and adhere to the relevant professional standards of care. That means that the daughter could not be approved for MAID if her sole condition was mental illness or disability. Later in these reasons, I explain that the court cannot review a MAID applicant's decision-making or the clinical judgment of the doctors and nurse practitioners involved in assessing an applicant's suitability for MAID. I'm going to put a big asterisk on that as we go, because there's a really big issue that is not sort of focused on because it's a different thing here, but it's a really big issue that needs to be sort of raised as one of the concerns here. The inability to review the clinical judgment of the professionals making MAID assessments precludes the court from going behind the medical assessments to question whether the daughter's sole condition is mental illness or disability. So, now there's a bunch of policies for Alberta Health Services, and one of the critical ones here, I'm not going to review all of them because it's lengthy and most of them don't apply. But if there are differing opinions, because remember, there needs to be two doctors signing off on this. They both need to agree. So if there's differing opinions with respect to the patient's MAID eligibility between the first and second assessors, a third tiebreaker assessment may be offered to the patient. The process for identifying a third breaker assessor is the same as outlined in paragraph 17. This is going to be a critical issue in this case, how they picked the tiebreaker. So stay tuned for that. WV is MV's father. He and the daughter's mother, PS, are in an adult interdependent relationship and live together. Neither the father nor the mother want the daughter to die. The daughter was diagnosed on February 25th, 2016 with autism spectrum disorder. Her doctor indicated in his diagnosis that she did not have any associated intellectual development or speech disorder. However, he specified that she suffered from the following associated behavioral disorders. So first is a level 1 social communication disorder severity, supports needed, and level 2 restrictive repetitive behavior severity, substantial supports needed. The father deposed that he and the mother have been the daughter's de facto guardians since she came of age. She's 27 years old and lives in their basement. She's never worked except for odd jobs for her parents and a brief stint for Elections Canada during an election. The daughter has a long history of seeking medical diagnoses for physical ailments, but to the father's knowledge, no diagnosis has been made. The father says that it is unclear to him whether the daughter suffers from a physical condition, and he speculates that she may suffer from psychological conditions that cause her to believe that she suffers from physiological symptoms. Now, this is difficult because this could be a mental disorder that's making her imagine physical conditions, right? That those kinds of issues exist. However, it could be that she's suffering from physical conditions and is unable to get a clear diagnosis. Myself, I've been having some mystery medical issues that I don't have a diagnosis for. And so, I mean, I'm not going to be signing up for MAID anytime soon, but, you know, lots of people deal with the serious problem of, I have some sort of physical condition that's causing me serious, distress, and doctors are not managing to track down what it is. So, unclear what is going on. So, Dr. SM's report to the daughter's family physician, dated July 16, 2021, detailed the following medical conditions reported by the daughter and reflected in her medical record. Possible migraine, autism, per chart. Attention deficit, per chart. GI symptoms. The patient reported that she underwent endoscopy in the past and was reportedly normal. The patient reported cardiac issues. On further clarification, she reported that she had SVTs and PVCs. Dr. SM's report to the daughter's family physician on July 16, 2021 explained that the daughter complained of the following symptoms. Generalized weakness since grade 5. A propensity for tripping and falling, numbness and tingling in her hands and feet with no progression to arms or legs, neck pain, though no back or pain or radiating pain, difficulty going upstairs for the last 5 years with no progression, shortness of breath, difficulty swallowing since she was a baby, and Dr. SM reported the following observations and conclusions to the daughter's family physician. Daughter was, and this is a quote, vague with the course of symptoms, that she looks well and not in distress, that she has normal muscle bulk, tone is normal in the upper and lower limbs, strength is 5 out of 5 in 16 different tests, that she has normal pinprick sensation. She stated that she had no difficulty with stairs in the clinic, and the patient electrodiagnostic studies are normal. There's no evidence of neuropathy, i.e., there doesn't seem to be a nerve conduction disorder like MS or something like that. The patient's physical examination is normal. We have no further recommendations at this point. So they don't know what it is or the like. So this is an issue. So the father deposed that, to his knowledge, recently the daughter has not been seeking treatment for any adverse physiological or psychological conditions. Her only recent interactions with medical professionals have been in pursuit of MAID. The father states the daughter's close friend, DLG, is an avid supporter of the daughter's MAID applications, and I fear that she may be unduly influencing the daughter's decisions to pursue MAID. He provided no documentary or other evidence to support his view that DLG was unduly influencing the daughter. The daughter's evidence confirms that DLG acted as her independent witness on her MAID application. Now, I don't know what's going on here because we have very little information, and this is sort of an application that is brought kind of on an emergency basis. And so their ability to marshal evidence is going to be somewhat limited. But certainly the father is making an allegation that this person is involved and sort of meddling and pressuring for that. And that's a whole other issue. I don't know what the actual background is. So the father deposed that the daughter applied for MAID on 2 occasions. The date of her first MAID application is not in evidence. Her first application for MAID was denied because one physician approved and one did not. Dr. P's counsel confirmed that the daughter made 2 MAID applications, and we'll hear more about Dr. P as we go on. The daughter made a second application for MAID in 2023. Again, one doctor determined her to be eligible, and the other did not. Alberta Health Services permitted her to obtain a third assessment to break the tie. The doctor selected to break the tie, Dr. P, is the same doctor who previously, in the context of her first MAID application, found her to be eligible. The father's assertion that Dr. P provided positive MAID opinions on both of her MAID applications was confirmed by Dr. B's counsel, who was present in the courtroom. So you see the issue here. How did they pick this tiebreaker, Dr. P? Because both times she goes in, she says, I want MAID, and one doctor says yes, and one doctor says no. But this second time, when they decide who the tiebreaker is, they pick the person who said yes the first time, which basically decides the issue, right? Wouldn't you want to pick a third doctor who's not been involved at all? This is one of the issues that the father is litigating, and this is a critical issue. So the daughter advised the father on December 13th, 2023 that she'd been approved for MAID and that her date of death was scheduled for January 19th, 2024. The father and the mother developed a family plan for her care and personal development in the hopes of persuading her not to proceed with MAID. She subsequently rescheduled her date of death to February 1st, 2024, and her death was prevented by the interim injunction issued by Justice Belzil on January 31st, 2024. So, this is, they were pursuing a guardianship application for the daughter, but they note that they tried to file it and the clerks bounced it. It's hard to get stuff filed sometimes. The clerks, and I'm not harshing on the clerks here, this is their job. There's a whole ton of requirements for what something has to meet in order to be filed. And so I've had instances where I've tried to file something several times because you make mistakes in the formatting. It's a thing. You know, if the page isn't numbered right, it's like, sorry, can't be filed. So that seems to be what's going on there, is just trouble filing it. That's, by the way, also why you get stuff done early, so you're not filing on the last day, because that's a very dangerous game. So, evidence of the daughter. The daughter submitted an affidavit dated February 18th, 2024. Her affidavit does not address her medical condition, any suffering she may be experiencing, or why she wants MAID. So she just didn't tell the court that at all. She was questioned on her affidavit on February 29th, 2024. At the questioning, she refused to answer questions concerning her medical condition and refused to produce any records that she had concerning the MAID assessments. She said, "That's none of your business, I'm not answering." On March 1st, 2024, the daughter opposed an application by the father to compel her to answer questions concerning her medical condition and provide the assessments of that condition performed by the doctors who approved her for MAID. So dad said, "I want those answers," and the court says no. I declined to order the daughter to produce her medical records or answer questions about her medical condition, as I did not consider the records and information sought to be relevant to her application to set aside the interim injunction on the grounds of standing and justiciability, nor did her affidavit put the records or information in issue. So the court basically is saying, we don't get to look, and when I say we, I mean the court, but also society, doesn't get to look at the basis for the decision. That's going to be between her and her doctors and them alone. The daughter deposed that she submitted a record of request for medical assistance in dying on August 10th, 2023. The request. Following submission of the request, Alberta Health Services arranged for the daughter to be assessed by 2 doctors to determine her eligibility for MAID. On August 24th, she met with Dr. G for a MAID assessment. Dr. G did not find her to be eligible for MAID. She then met with Dr. F for another MAID assessment, and Dr. F concluded that she was eligible for MAID. If you're wondering why the doctors' names are hidden, it's because if you knew all of these doctors, you could probably figure out who she was, if you had sort of medical anything. So, on November 6, 2023, Alberta Health Services advised the daughter that one doctor had approved her for MAID and the other had not. Alberta Health Services further advised her that she had the option of seeking a third assessment as a tiebreaker. She asked for the third assessment. Dr. P performed the tie-breaking assessment on November 26, 2023. The daughter did not explain how Dr. P was chosen to perform the assessment. So you wonder, did she get to choose this? Like, how did this come about? Dr. P approved the daughter for MAID. The following day, November 27, 2023, Alberta Health Services notified the daughter that based on her medical assessments, she had qualified for MAID and could schedule an appointment for her death anytime after January 12, 2024. So, that's kind of our background. Now, let's talk a little bit about sort of the legal issues here. So first is justiciability of the doctor's MAID assessments. Can the court look at the doctor's assessments at all? And they look at a case which is AB and Canada Attorney General. AB was an application brought by an 80-year-old woman who was suffering from a form of arthritis that caused her to be bedridden and suffer from constant excruciating pain. 2 doctors had determined that she was eligible for Track 1 MAID. So that's that her death is imminent. So a third doctor, however, provided a dissenting opinion. The 2 doctors who had determined that she was eligible for MAID would not provide her with MAID out of fear of criminal liability. This is the elephant in the room, which is, if the doctors doing these assessments get it wrong, and if it's found that they are wrong in how they go about it, then all of these protections that allow for MAID to take place go away. And instead, what you have is a case of straight up murder. And that's a big thing. So that's why AB's doctors weren't keen on going ahead, is they were like, we don't want to go to jail for the rest of time for being murderers. Because that's a mandatory minimum of life in prison. without parole for a good long time. So, though they considered her death reasonably foreseeable and were concerned about the vagueness of the words reasonably foreseeable and the potential that police or a court dealing with matters after AB's death might interpret those words differently, AB brought an application to the court for a declaration that she was entitled to MAID in the hope that such a declaration would give her doctors the assurance that they needed to provide her with MAID without fear of criminal liability. So she basically went to court and said, tell the doctors it's okay to kill me and that they can't be prosecuted afterwards. And the court says, that's not what we do here. This is a Wendy's. AB's application was opposed by Ontario, the province, and Canada. Ontario and Canada submitted that an application for a declaration of eligibility for MAID was contrary to the intention of Parliament because the concept of judicial pre-authorization for MAID was considered and rejected. And that was basically, they're talking about like the debates about how they set this up. They further submitted that a declaration of eligibility interfered with prosecutorial discretion by effectively preempting the possibility of criminal liability. They said, we actually want to be able to charge people if they screw it up, or if we think that they got it wrong, we want to be able to lay charges. So that's a thing. Justice Perel at paragraph 4 called Ontario and Canada's positions as unhelpful as it is technically correct. So basically the court found that they couldn't like preemptively declare this, but they did issue a declaration to say that they thought that her death was reasonably foreseeable. So, and they did that basically by purely just accepting the medical view of the doctors. They didn't dive into that. So the court goes on in this case to say, MAID assessments are conducted in accordance with the structure imposed by the Criminal Code and the Alberta Health Services MAID policy, but they remain medical assessments conducted by doctors and nurse practitioners. Medical assessments conducted by doctors and nurse practitioners are private in nature and involve the application of specialized professional judgment. Though the court will review the conduct of doctors and nurse practitioners after the fact, in, for example, professional negligence cases, those circumstances occur at trial and typically with the aid of expert witnesses. The court has no expertise and no place in reviewing MAID assessments in some sort of ad hoc system of pre-authorization. It is not the court's legitimate role. To take on such a role would undermine the confidence of the public in the court, as well as undermine the MAID structure established by Parliament in the Criminal Code and copied in the Alberta Health Services MAID policy. So basically, they're saying we can't review the doctor's decisions. The doctors make their decisions and they stand or fall on those decisions. There's a lot at stake on those decisions for the doctors, but we don't get to review that until afterwards. Afterwards, the Criminal Code provisions can provide for a review. And if I'm a doctor, I am absolutely terrified of that because there's a lot at stake for the doctors. So Justice Bourgeois concluded in Sorensen that the court does not have the institutional capacity to become a clearinghouse for MAID pre-authorizations. She expressed concern about the court's resources and ability to handle a potential avalanche of urgent MAID applications. Now I'm concerned about the possibility of an avalanche of MAID applications because this seems like it should be something that is rare as opposed to common. But, you know, that's a question for someone else. It is enough to say that the court has no legitimacy in reviewing the professional judgment of doctors and nurse practitioners, even if the court had endless capacity to adjudicate disputes that could not justify extending its reach to areas where it has no legitimate place. So that's the court's ruling on that. However, they come to a different conclusion with regards to the justiciability of Alberta Health Services administrative actions. So, and this, Alberta Health Services as in like the hospitals writ large. So they say the Alberta Health Services MAID policy, like the Criminal Code, requires that a doctor or nurse practitioner providing a MAID assessment be independent. The requirement for independence is essential to a MAID assessment being objective. The AHS MAID policy adopts and repeats the Criminal Code definition of independence with some minor changes that do not affect the meaning. The policy provides that a MAID assessor is independent if they do not know or believe that they are connected to the other physician or nurse practitioner or to the patient making the request in any other way that would affect their objectivity. The father alleged in his affidavits that Dr. P, who provided the tie-breaking MAID assessment for the daughter, knew or was connected to the daughter because he'd previously provided her a positive MAID assessment in her initial unsuccessful attempt to obtain MAID. Dr. P's counsel confirmed that Dr. P had indeed previously provided her a positive MAID assessment during her first MAID process. The father's allegation is that Dr. P lacked objectivity because he had already formed an opinion on the daughter's eligibility for MAID. At this early stage of the litigation, and without prejudging the merits, I conclude that the court is saying basically, we haven't heard evidence on this. We haven't cross-examined on this. We can't judge this at this stage. So the question is really, has he raised a viable issue? And so they say, I conclude that the father has adduced an arguable case that Dr. P was not independent and that he provided a MAID assessment contrary to the Alberta Health Services MAID policy. To be clear, the issue is not what conclusion Dr. P had previously come to, but rather that he had already assessed the daughter for MAID and formed an opinion on her eligibility for MAID, something which was known by both the daughter and Alberta Health Services. So, this is significant because, if we imagine the court scenario, a judge who makes a ruling on the person, for instance, a judge who handles a bail hearing, may not be able to handle the trial because they've already come to conclusions about this person. If the judge says on record, I think this person is dangerous, or I think this person is not credible, when they hear the bail hearing, it would be inappropriate for them to then hear the trial because, they've already made a decision about this person. They're no longer objective. They're no longer coming at it with a clear, fresh mind. So the court is saying that's not a crazy argument with respect to Dr. P. So there is no evidence before the court as to how Dr. P was chosen to provide the tie-breaking MAID assessment for the daughter. The evidence of Dr. S.G. that explains the Alberta Health Services MAID process, however, details that the AHS MAID navigator, who is an Alberta Health Services employee, plays a significant role in the selection of MAID assessors and in arranging for MAID appointments. By permitting Dr. P to provide the tie-breaking MAID assessment while knowing the result of his prior MAID assessment of MV, the daughter, the MAID navigator arguably decided the outcome of the process. And is this MAID navigator a doctor? Are they this seems like there's something sort of hinky going on in this process, right? The actions of the MAID navigator in selecting Dr. P or accepting the daughter's choice of Dr. P are administrative actions. And because they're administrative actions, they are reviewable. The court ultimately concludes the subject matter of the father's complaint, whether Dr. P is independent, is a straightforward application of the MAID policy that does not engage specialized medical knowledge. Courts deal with questions like this every day. It is a question that is suitable for judicial consideration and raises no questions about the legitimacy of the court. Having determined that there is a justiciable issue appropriate to be judicially reviewed, I now turn to consider whether the daughter has standing to review the administrative actions of AHS's MAID navigator. Standing is going to be a big problem. I mentioned standing before. Not everyone, and the court notes, not everyone who may want to litigate an issue should be entitled to do so. Let's say I want to build something in my front yard, and, I want to build a big ugly statue. My neighbors might be able to sue me over that because, I'm their neighbor. But somebody in Quebec, which is across the country, shouldn't be able to sue just because they don't like the idea of me building a big ugly statue in my front yard. So, and I'm not doing that. Neighbors don't sue me. But you see sort of how this is. It can't be that the entire world has access to a claim. Certainly, for instance, if I wanted to sue MV to say like, hey, you can't do this, the courts would quite properly tell me, go away. This is not your problem. But the question is does the father have standing? And this is a difficult question because we sort of recognize that there's a different relationship there. But ordinarily, a father wouldn't be able to have a say in an adult daughter's medical decisions. And this is what the court, first has to consider with respect to private interest standing. They say the father does not have a legal interest in the daughter's medical decision-making or in Alberta Health Services administrative actions with respect to the daughter's medical care. He is, in a legal sense, a stranger to her interactions with doctors and Alberta Health Services administrators. And that might be hard to read, but for instance, my father would not be able to pull my medical records. They would treat him the same way as if like the police asked for them, or a homeless person asked for them, or you asked for them. They'd say no. So the father does not have private interest standing, though he is certainly aggrieved in the sense that someone he loves has been approved for MAID, and he's concerned that the appropriate process has not been followed. That is not a legal interest, the court says. They continue to say the considerable flexibility to recognize private interest standing should not be exercised in the present case. Finding that the father has standing as of right in relation to his adult daughter's interactions with the healthcare system would set a dangerous precedent. Specifically, that a person has standing as of right to challenge the medical decision-making of an adult family member and their doctors. This runs contrary to the presumption of the capacity of adults. And keep in mind that once they set this principle, it ends up extending beyond its original facts. So what about, for instance, let's say I develop something that is annoying, right? A medical thing, that is causing me annoyance. Like, let's say it makes it hard for me to eat. And so I'm having trouble keeping food down, and I find this really annoying. And it turns out that there's a surgical procedure that could fix it, but that surgical procedure, maybe it's got a 30% chance that I'm going to die. And I determined that I think it's I think that's a good deal, right? I think, okay, I want to roll those dice. But let's say my parents go, no, you should have to live with this and not get the surgery. I think I should be able to tell them to go away. And that's what the court says. That's what the law currently says. And the court is unwilling to extend that any further. Keep in mind as well, some people have very contentious relationships with their parents. Some people don't get along with their parents. Some people's parents are abusive, or, whatever else. So the court continues. Furthermore, the requirement that it be in the public interest that the case proceed and the court's discretion to grant or withhold public interest standing is an important protection that ensures that standing will not be routinely granted to litigants objecting in the medical treatment of family members. So, public interest standing. This is where you want to sort of intervene and engage in litigation as sort of a member of, usually this is like organizations or whatever else, but not always. So the factors that a court must, and so public interest standing is another way of getting standing. You can get standing in a case where otherwise you might not, so long as you meet certain factors, which the court's going to identify here. They say first, whether there's a serious justiciable issue raised, which the court has already said yes, right? They've already said yes to this. 2, whether the plaintiff has a real stake or genuine interest in it. And 3, and the reason why they want you to have a real stake or a genuine interest in it is they want all litigation to be pursued by people who have an active, that they've got skin in the game, that they care about it, because they don't want people intervening in cases in order to like throw the case and create bad precedent. And 3, whether in all the circumstances the proposed suit is a reasonable and effective way to bring the issue before the courts. So the first one we already covered, right? It's over, it's done. They decided that. The second factor does not demand that the plaintiff be the perfect person or organization to bring the matter forward, only that the person or organization have a real stake or genuine interest. The father does not fit comfortably into the profile of the typical litigant that is granted public interest standing, because again, usually that's like organizations and so forth. They say he's an individual, not an interest group or service organization, and his interest is decidedly recent and personal. Counsel for the father explain his interest in their written argument as follows. The father faces the death of his daughter through lack of proper governmental oversight and administration of MAID. The father is certainly not a busybody or a dilettante, i.e. they don't want somebody who's just a meddler. You can't just be like, I want in on this. The father is represented by capable counsel, and there's no suggestion nor any evidence that the father cannot fund the litigation. And the reason why that matters is because if you're going to run out of money and end up tanking it, that's not good, right? That doesn't get you a proper hearing. HS and the daughter complain that the father has not provided an undertaking in damages. So basically that he hasn't promised that he will pay the damages and that he can pay the damages. But this, of course, presumes that Alberta Health Services and the daughter could plausibly suffer damages as the result of an injunction. Damages are, you get some sort of loss, right? If the injunction continues, Alberta Health Services will not have to provide a medical service to the daughter. Thus, they won't suffer damages. It's not damages to just not do a procedure. The daughter, for her part, will remain alive. Perhaps she will experience suffering, which could be compensable in money damages. And this is the court saying could, they're not saying will. But the court has been denied any insight into that because she chose not to adduce any evidence concerning her medical condition or how it causes her to suffer. Court's already said, if you don't want to tell us, we're not going to dig into it. But there are sometimes consequences of not telling the court things, which is court can't conclude that you're in suffering if you don't tell them that. As such, I find that no undertaking in damages is warranted, and therefore take nothing from the father's refusal to provide one. I am satisfied that the father has the capacity to bring the claim forward. The case is of public interest. The MAID provisions of the Criminal Code are still relatively new, and there's been little judicial consideration of the MAID provisions, particularly the 2021 amendments that created Track 2 MAID. So, the court says, I am satisfied that the father is an appropriate plaintiff to advance the proposed judicial review proceeding, and accordingly grant him public interest standing. So, what they've basically said is that there's this discretionary category of standing, public interest standing, and so he doesn't have private, interest standing, so he doesn't have standing as of right, and other people in a similar position to him won't have standing as of right, but he'll have public interest standing in this particular case, and other people later might not. Other parents might not, because this issue will have already been litigated in this case. So that's what that means going forward. So now for injunctions, they're going to look at the proper test for an injunction. And an injunction is when the court says you can't do a thing, right? And so in this case, the injunction that was there is the court saying you can't go ahead and kill this woman. So the test is first, that there's a serious issue to be tried. We don't grant injunctions over nothing. Second, that irreparable harm would result if the injunction is not granted. And this one is going to have some wrinkles. I know I can hear a lot of you viewing this saying, obviously there's irreparable harm. She's going to be dead. There's a wrinkle to it, and we'll get to that. And the third thing is the balance of inconvenience between the parties favors granting the injunction. So basically the court is going to make some weighing of these things in order to determine which side, because often an injunction will cause issues for both sides, or if the injunction is not granted. So first, serious issues to be tried. They note, has the father raised a serious issue to be tried that the daughter's death would be wrongful? The evidence of the daughter and Alberta Health Services establishes that Alberta Health Services played a significant role in helping the daughter navigate the MAID process, including recommending or selecting MAID assessors for the daughter or accepting MAID assessors chosen by the daughter. Allowing a MAID assessor who had previously, to the knowledge of both the daughter and Alberta Health Services, formed an opinion on the daughter's eligibility for MAID to act as a tiebreaker may plausibly be argued to be negligent or wrongful, as it is arguably contrary to the independence provisions of the Alberta Health Services MAID policy and the Criminal Code. Without having access to further evidence that could be available at trial, and without expressing any views on the merits of the daughter's case, of the father's case, at this stage he has raised serious issues to be tried. And I gotta tell you, if I am a lawyer for the doctors involved in this, I am crapping my pants. And I am telling my clients, you need to be aware that after the fact, this may be reviewed by prosecutors. And after the fact, they may determine that there was not independence. And if that's their determination, they may bring murder charges. So the doctors who perform the procedure are risking, given that the court has said there's a serious issue up in the air, they're risking the possibility of murder charges and possibly a murder conviction. If I'm that doctor, and I'm not giving them legal advice, they should talk to their own lawyers. Their lawyers know the situation better than I do. But, just from this, I would be going, dibs out, not it. Because I don't want a piece of that. I don't want to play that gambling game here. So as set out earlier in these reasons, the doctor's judicial review proceeding appears, at least on a prima facie basis, so as a starting point, to be arguable. Accordingly, the father's judicial review proceeding also raises a serious issue. Now we move on to irreparable harm, and I said this one was going to be complicated. Here's the complicated aspect. The irreparable harm that must be demonstrated is irreparable harm to the applicant. So the father must show that he will suffer irreparable harm, not that the daughter will suffer irreparable harm. Because the daughter, clearly, right, death is an irreparable harm. That's sort of the textbook thing. The thing is that is his sorrow over that an irreparable harm. So the test for whether the harm is irreparable was set out by the Court of Appeal in May and Numbered Company, and the court, quoting another case, explained, the test is whether no fair and reasonable redress can be had in a court of law unless the injunction is granted, and that its refusal would be a denial of justice. The Court of Appeal has also used the well-established formulation, harm not compensable in damages, to explain the nature of irreparable harm, i.e., harm that money can't solve, right? This is the big thing. Can we solve this with money? And if money isn't going to fix it, then it can be irreparable harm. So they note, the father's irreparable harm is the grief and loss that he will suffer if the daughter dies a wrongful death. This harm is, to an extent, compensable in money damages in a wrongful death suit pursuant to the FAA. However, the FAA and its assorted regulations limit the damages that may be recovered, i.e. there's a cap on how much money he can get back, which means he might not be able to repair this with money. They say, I accept that the pain and grief of losing a child cannot be measured, and that no amount of money damages would truly suffice. Accordingly, the father will experience irreparable harm if the daughter suffers a wrongful death. The weight that the harm to the father should carry in my analysis will be discussed at the next stage of the injunction test. So they do find that it's an irreparable harm. But the next step is the balance of harms. And the court is going to sort of explain their balancing act. They say the harm to the father if the injunction is not granted will be substantial. The pain of losing a child, even an adult child, is not something that any parent should experience. The father and the mother have devoted their lives to raising the daughter from birth and have continued to support her since she has come of age. They will understandably be devastated by her death. For many parents, the loss of a child is a life-changing event that they never truly recover from. The loss is immeasurable. The harm to the daughter, if an injunction is granted, goes to the core of her being. An injunction would deny the daughter the right to choose between living or dying with dignity. Further, an injunction would put the daughter in a position where she would be forced to choose between living a life she's decided is intolerable and ending her life without medical assistance. And so the court is noting it might happen anyway, even if there's no medical assistance in it. This is a terrible choice that should not be forced on the daughter, as attempting to end her life without medical assistance would put her at increased risk of pain, suffering, and lasting injury. Though I have determined that the balance of harms weighs in favor of the daughter, nothing that I have written should be taken to minimize or diminish the father's potential loss. The father can perhaps take some solace in the fact that he did his best to persuade the daughter of the value of her life and her parents' commitment to loving and supporting her. Ultimately, the court finds in favor of the daughter on the balance of harms. And so the conclusion is that the interim injunction is set aside, which means that the daughter will have the ability to proceed with her death. However, there's a big wrinkle on this. At the father's request, and with the consent of the daughter and Alberta Health Services, this decision is stayed for 30 days to permit the father to commence an appeal. So he is able to appeal this, and the appeals court can grant a further injunction. The interim injunction shall remain in place for the duration of the stay. Any application for an extension of the stay should be made to the Court of Appeal. So basically, he's got 30 days from that decision to file an appeal and to ask the Court of Appeal to say, please stop this, because, you know, if it goes through, there's no way to undo it, right? The Court of Appeal does not have the power to bring people back to life. It's just not something our courts can do. So, that decision came out March 25th. So that starts our clock. I don't have an appeal of this at this stage, but I mean, that's not all that surprising because these things take some time, right? It takes some time to file a notice of appeal to get all that together. I suspect that the father is working as fast as he can to get that in, and ultimately the Court of Appeal is going to have to decide this. This is a very difficult question that raises very serious concerns as between the two of them. Now, a lot of people have pointed to the issues of exactly what her diagnoses are, because the sort of firm diagnoses appear to be autism and attention deficit. And this has a lot of people concerned because the whole political considerations around MAID are, is this going to be something that becomes available to sort of too many people? And especially, are there going to be people who are pressured into it? And that's certainly an allegation that the father has raised here, is that there's pressure from this third party. So this case is going to be ugly. It's going to be contentious. And so I hope I haven't injected too many of my own editorializations. I can tell you, I don't really know how I feel about this one. I'm very conflicted in a lot of ways. And a lot of it comes down to, I don't have enough information to really know what's going on. So yeah, please don't fight in the comment section. This is a tough issue, and hopefully we understand it a little better now that I've explained it. As I said, I'm going to link the full decision if you want to read it. I did skip a lot of it just to give you guys the basis to understand it, but there's a lot more in there. And, you know, if I went through everything, this video would be 3 hours instead of probably 1 hour. So, and an hour is a long video. Thank you for your patience in getting through this one, but it's a really important topic. I'll do some shorter videos soon, I promise. I know a lot of these have been really long and really weighty, and it is what it is. So, I thank you guys for trusting me to deal with some of these difficult, or to talk about some of these difficult cases. I don't know what YouTube is going to do in terms of like monetization or anything like that. They may take issue with this video. I don't think it violates any of their rules, but maybe. So, yeah. Anyway, I'm gonna, and this one I'm going to do something I don't usually do, which is I'm going to omit the reading of the Patreon supporters. And that's because this is a very contentious topic, and I don't necessarily want to tag anyone on an issue that they may or may not have strong feelings about. So if you're a Patreon supporter and that upsets you, let me know. But I didn't think that this was the one to sort of put people's names on. But I really do thank you guys for watching this video. I hope you found it to be informative and let you know what's going on this one. A lot of people have been reading the news stories, and the news stories, of course, don't really dig into the substance of it. And this is an important issue. So thank you for watching. I hope this has armed you with knowledge. See you next time.